Meeting provisions.
So I'd like to call this meeting to order. The time is 9:00 a.m. and today is March 23rd, 2023. This is the second day of our two-day meeting of the Physical Therapy Board of California. Today we are meeting at the University of the Pacific, 751 Brookside Road, Stockton, California, 95211. In rooms PHS 110 and 111. This is an official business meeting of the Physical Therapy Board. The board's role remains to maintain consumer protection and consult with local and state entities on the laws and regulations pertaining to the physical therapy industry. We will take public comment on specific agenda items, and there will also be an agenda item for comments for items not on the agenda. Public comments must be specific to the agenda item that is being discussed. If you make a comment during a specific agenda item that is not related to that topic, you will be directed to hold your comments until we reach the appropriate agenda item. All comments that do not directly relate to an item on the agenda should be held until the agenda item for items not on the agenda. The board follows the Open Meeting Act, so while we accept and appreciate the public's comments, we cannot respond to those comments. This meeting is being recorded and minutes of the meeting will be prepared. Can we please have roll call?
Tanya McMillian.
Present.
Dale Armstrong. Here. Karen Brandon.
Present.
Daniel Drummer.
Present.
Katarina Eller. Present. Jonathan Irvin. Jonathan Irvin is absent. Alicia Rabin-Ahmed. Here. All members are present with the exception of Jonathan Irvin. The board has a quorum.
Thank you. Now I'd like to ask Dr. Daniel Drummer to read the board's mission statement.
The mission of the Physical Therapy Board of California is to advance and protect the interests of the people of California by the effective administration of the Physical Therapy Practice Act.
Thank you, Dr. Drummer. So we will resume our agenda for today. We are on agenda item number 18, the legislation report.
The legislation report begins on page 67 of the meeting materials. It is early in the session and we are watching over 45 bills thus far. Many of the bills presented today are in spot form with proposed legislative language forthcoming as we progress through the session. Currently, most bills are in the policy committees in the Senate and Assembly, and June 2nd is the last day for each house to pass bills introduced in that house, and September 8th is the last day to amend bills on the floor. September 14th is the last day for each house to pass bills, and the governor has until October 14th to sign or veto bills in his possession after September 14th. All statutes will take effect January 1st, 2020. So for the legislative summary, before I begin going through all of the bills presented to the board today are grouped in two categories. Physical Therapy Board legislation, which are bills that could potentially impact the PTPC, PT practice, regulations, or the operations of the PTPC. The second category is department-wide legislation, which are bills that could potentially have a department-wide impact or more of an administrative effect on or impact to the PTPC. I'll start with the first bill on the legislative summary, and that is AB 47, pelvic floor physical therapy coverage, which was introduced on 12/5/2023. This bill is currently in the Assembly Health Committee. This bill would require a health care service plan contract or health insurance policy issued, amended, or renewed on or after January 1st, 2024 to provide coverage for pelvic floor physical therapy after pregnancy. And I'll continue going down the list, and if you have any questions or would like to discuss the bill further, I'll
You did include, Brooke, some possible positions taken by the board on the previous page.
I think at this point in time, staff are recommending a watch position because it is so early in the session.
Yes.
Some of these bills are in spot, most of them are in spot, and a lot of them don't have all their legislative language.
Yeah, I figured that's why some other positions weren't even included. It's just so early.
Yeah.
That's what my question was. Thank you.
And what I think you're referring to in the materials is a copy out of the administrative manual that just defines what the support means for each section. As Brooke said, this early in the session, we don't have staff recommendations, but the board's still free, for conversation and these purposes with the agendized materials, to have that conversation, and should you come up with a position, we'll draft it for you.
I think my question is like, why wasn't other positions included on here? I know it's out of the manual, but like in opposed or something like that. I realize it's,
Oh, it's just a direct page
Yeah.
right out of the
Yeah.
administrative manual, but of course, the board, there are other positions that you
Yeah.
can take.
thanks.
Actually, I think that is a conversion of a PDF.
Oh, did we lose it? I
We
think we
the
lost
half
the,
page.
we did. That explains it.
Okay, thank you. So it was supposed to be included, it just isn't there. Okay, thank you.
Brooke, I have a question. Are we going to be able to have a conversation as a board about these again before or after, our next, because you said June 2nd was the date that,
And our next meeting is, I believe, June, the third week in June, so.
That's the third week.
okay.
If there, with any legislation, if there is anything that's emerging, the board can always call a meeting in between, an emergency meeting, or even a pre-scheduled meeting to discuss things. And it would be up to the board president to decide whether that's warranted or not. But today also is an opportunity to discuss these bills early in the session. As those bills move from one committee to another, we'll have opportunities through our subsequent board meetings to have discussions as well.
I just wanted to maybe pick Member Brandon's brain because I think this is a very important bill, the one that we're looking at right now. And I mean, we won't have an opportunity to have another meeting and maybe take a position before the next meeting. I'm wondering if that's what your thoughts are.
Yes, thank you. Well, speaking to this, I know that this Assemblywoman in San Diego had brought this forth because of challenges she had in her own pregnancy, her experience, and her positive experience with a physical therapist. And I know also at the federal level, there's a lot of interest in supporting fourth trimester care as a completion of care and support for mothers who are definitely at risk. And I would say the challenge at risk is the fact that currently it's not covered by Medi-Cal. And so I think that there's a lot of good reason why making sure that the coverage is equitable and that we can encourage people to get quality care from providers who are skilled in this, and our board would, I think, be in support of that.
I do agree. This is very important for the consumers of California to have access. I'm even thinking as a consumer myself and having children years ago, this would have been wonderful for me. Yeah.
Am I hearing a motion?
Am I hearing a motion? Yeah.
No, I want to propose a motion that we be in support of this bill because I think that it definitely supports quality and regulated care for this type of population in California.
I'll second.
I need to make it up.
We'll record it as a motion.
Thank you.
Any discussion?
I'm wondering if the author of the motion would like to include development of a letter of support to send to the author of the bill as well as other relevant parties. It's something that we've done in the past.
Thank you.
I still second.
Any further discussion? Hearing none, can we take a vote? Oh, public comment?
Good morning.
Morning.
I'm Stacy Defoe. I'm Executive Director for California Physical Therapy Association, and I just wanted to let you know that we are also in support of this bill. We think it's great for all the reasons that you outlined. Thank you. And would appreciate your support of the bill as well.
Thank you. Now, you can call for a vote.
Tanya McMillan,
Aye.
Dale Armstrong,
Aye.
Karen Brandon,
Aye.
Daniel Drummer,
Aye.
Katerina Ellery,
Aye.
Jonathan Irvin. Jonathan Irvin is absent. Alicia Van-Amen.
Aye.
6-0, motion carried.
Staff will draft that letter and provide it to the board president for signature and her approval, and then we will get that to the author so that they understand our written session.
Okay, the second bill on the legislative summary is AB 381, Teacher Credentialing Services Credential with a Specialization in Health, Occupational and Physical Therapist. This bill was introduced on February 2nd and is currently in the Assembly Education Committee. This bill would allow occupational therapists and PTs to use their specializations to hold teacher credentials with a specialization in health. This bill specifically would delete the provision specifying that services as an occupational therapist or physical therapist are not health services for purposes of a services credential with a specialization in health.
Was a form of this bill presented last year?
It was.
And I believe this board did take a support position at that time. Is that correct?
I believe the board decided to take a position at that time. But I believe the bill in the last legislative session died in committee.
I move that the PT board take a support position on this bill and direct the EO to draft a letter to the author and present it to additional relevant parties.
I second.
Motion and a second. Any discussion? We have a motion and a second. Any discussion?
I'm sorry, Dan. I remember the conversation somewhat from last year and that there was a significant delay in services for children. And so I just want to point that out, and I do feel like it's important for us to protect the children and get them the services that they need in a timely manner.
And as a PT in the school district, I totally agree.
Any public comment?
Good morning, Stacy Defoe, California Physical Therapy Association. I just wanted to let you know that this is a CPTA-sponsored bill, and this is probably the third iteration of the bill, pretty much the same as you've seen before, for the reasons you've both outlined, are the reasons that we are promoting this bill. We do feel like we have more support for it this year, so we feel pretty positive about it going forward, and would appreciate your support.
Okay, and we have a roll call vote.
Tanya McMillan,
Aye.
Dale Armstrong,
Aye.
Karen Brandon,
Aye.
Daniel Drummer,
Aye.
Katerina Ellery,
Aye.
Jonathan Irvin. Jonathan Irvin is absent. Alicia Van-Amen.
Aye.
6-0, motion carried.
Staff will draft that letter for presenting to the board president for signature and approval, and we'll distribute it to the authors.
Okay, Okay, the following bill on the summary is AB 557, Open Meetings, Local Agencies, Teleconferences, which was introduced on February 8th, 2023, and is currently in the Assembly Local Government Committee. This bill would, until January 1st, 2026, extend the time required to make specified findings related to the teleconference meetings being held by legislative bodies operating under the Ralph N. Brown Act during declared states of emergency. So this specific teleconference bill is related to declared states of emergency. The next bill is AB 796, Athletic Trainers, and was introduced on February 13th and is currently in the Assembly Business and Professions Committee and the Assembly Committee on Arts, Entertainment, Sports, and Tourism. This bill would enact the Athletic Training Practice Act, which would establish until January 1st, 2028, the California Board of Athletic Training within the Department of Consumer Affairs. This board would exercise licensing, regulatory, and disciplinary functions under the Act. This bill would additionally prohibit a person from practicing as an athletic trainer or using certain titles of terms without being licensed by the board. This is probably the 7th version of this bill. We see it, if not every legislative session, every other legislative session. So it's similar to the bill that was put forth last session as well. So the language is very similar to that.
I will say that it is a little bit more complete in this legislative session this early in the session. So the proposed language is amends a lot of general provisions, adding the Athletic Training Board to the Department of Consumer Affairs, specifying how the board is comprised, the fees, those kind of things. So they're a little bit further in the session than they've been in the past.
In regards to the scope of practice that's included in this bill, is there duplicative services similar to physical therapists?
Yes, I do believe that there's some, what would be inferred as overlap.
So it seems prudent at this point to take a watch position, or just to watch it.
Mm-hmm.
Yeah.
Okay, AB 814, Veterinary Medicine, Animal.
So, Madam President, we can take public comments now on each bill, or we could take them at the end. I think that's your discretion.
Thank you.
Is it okay? No. All right. So I'm Stacy Defoe, Executive Director for California Physical Therapy Association. Obviously, we are watching this bill. We are reviewing the language. We haven't taken a formal position at this point, but we do feel that at this time, as written, it doesn't adequately define the scope. It's pretty vague on that specific area as far as we're concerned, and so we're looking at that. And the supervision requirements are also not quite to where we would like to see them. So we're not, we're not opposed to athletic trainers receiving licensure. We're still not 100% convinced that it's necessary, but we're not opposed to it. But we would like to make sure, to help make sure that the language that if it goes forward, it adequately defines the scope and the supervision. Thanks.
All right, AB 814, Veterinary Medicine, Animal Physical Rehabilitation was introduced on February 13th and is currently in the Assembly. The Veterinary Medicine Practice Act provides for the licensure and regulation of veterinarians and the practice of veterinary medicine by the Veterinary Medical Board, which is within the Department of Consumer Affairs. That act makes it unlawful for any person to practice veterinary medicine in this state without a license and provides that the practice of veterinary medicine includes, among other things, the treatment of whatever nature of the prevention, cure, or relief of a wound, fracture, bodily injury, or disease of an animal, This bill would state the intent of the legislature to enact subsequent legislation to authorize a veterinarian to refer an animal to a licensed PT holding an advanced certification to provide animal physical rehabilitation under the supervision of a veterinarian.
So I would say that it's very early in the session, and in the materials in which you have in front of you really just expresses the author's intent of what they want to do during the session. So again, very early. We're still waiting for amendments for that bill to be published. But it's definitely something that, staff will be watching throughout the session as well.
Jason, do we know if where the Vet Med Board stands on this language at this point? In the past, I believe the Vet Med Board has been the primary opposition to moving forward with this.
That's correct. In the past, in the last legislative sessions, they have been opposed to the idea. For this legislative session, I don't believe they've had an opportunity to discuss or confirm an actual position on the legislation, which I think is fair, given that it's just at this point the intent. I know that we have some interested parties that would like to discuss this bill this morning as well, so maybe that will help us with this conversation.
Thank you.
Does anyone have any information regarding the advanced certification requirement, like exactly if there's one entity that's identifying the requirement?
I'm aware of that. I won't speak to it. I'll let some of the experts in the room educate us on that a little bit more.
Any other board comments? Public comment?
My name is Karen Atlas. I have been a licensed PT in California for 26 years, with about 12 of those years serving humans and about 14 of those years serving our canine patients. I'm also the president of the Animal Physical Therapy Coalition, which is a coalition comprised of physical therapists, veterinarians, registered vet technicians, educators, and consumers. The APTA seeks to establish common sense laws and regulations to increase safe access to animal rehab care in California. It's been well established that there is an access to care crisis for owners seeking treatment for their pets. We recognize that animal rehab is one area of care where the access issue can be mitigated with a legislative remedy. Assemblymember Josh Lowenthal introduced AB 814 on February 13th of this year. At this point in time, AB 814 is still a spot bill with the full amended language to be posted any day now. The intent of the legislature is to enact language to address the access to animal rehab care deficiency in California. As amended and shared with the board staff here, AB 814 does not create a new special license for PTs to practice physical therapy on animals. Rather, it provides a pathway for a licensed PT who has received advanced education, training, and certification in animal rehab to register with the Veterinary Medical Board to become a legitimate provider of these services. A DVM would then be empowered after they have examined, diagnosed, and determined that rehab care would be beneficial for their animal patient. Then they can refer their animal patient to an authorized physical therapist and provide their supervision. This measure does not encroach upon this board's regulation of licensed PTs. It seeks to narrow any burden upon this board through several provisions. Number one, it clarifies the PT Practice Act does not prohibit a licensed PT from performing animal rehab under the Veterinary Medicine Practice Act. Number two, it makes clear that the violation of the Veterinary Medicine Practice Act's provision for animal rehab by a licensed PT constitutes unprofessional conduct under the PT Practice Act. As such, it would require the VMB to report their disciplinary actions to this body. And the PTB would remain the sole authority of the PT license, but the VMB would have the ability to revoke or unauthorize the physical therapist from practicing on animals. Finally, AB 814 calls for the physical therapist PT board and the Veterinary Medical Board to work cooperatively to establish the necessary education and training standards to ensure competency of these authorized PTs. We're happy to have the support of the CPTA and numerous PTs, of which this stack demonstrates, as well as veterinarians, animal welfare organizations, educators, and consumers. We appreciate the board considering this bill, and we're eager to discuss a workable solution that serves the best interest of California animals and the people who love them. Thank you.
Dr. Actis, you had provided to us draft language
We did.
from the coalition in advance. Is that something that we can disseminate to the members? Is it too early for that? We can do
Yes.
that? Okay. We'll get that to you.
You have copies.
Michael Kenotes, legal counsel. I don't know how many members of the public we have here, but if they can also be available to
Absolutely. We have
members of the public, if anyone would like one.
Mr. Ayers?
Okay, thank you. I'm G.V. Ayers. I lobbyist representing the Animal Physical Therapy Coalition, and we're just here, glad to be here and speak to you about this bill. As was said, the bill is still in spot form. The amendments have been submitted, and we anticipate them any day. They were not, as of 10 minutes ago, not published in the bill yet, but they will be there, and we're glad and eager to work with you in dealing with any concerns with any of the language. We've tried to very narrowly craft what the impact on this board and the impact upon the act. Basically, one thing we've tried to narrow any enforcement burden on the board by saying in the bill that the vet board would report any disciplinary action to the PT board, and then that report of disciplinary action is conclusive proof of a violation of the PT Act, of professional conduct in the PT Act. So trying to narrow that down to where you would not and your enforcement staff would not have to go looking at veterinary med issues in that sense. That because we feel very strongly that the responsibility of the PT who involves himself in this is very serious, and they need to take this very seriously and do this in a way which is appropriate for the consumers here in California. We have our letter. Got here a little later. I would have given it to you earlier. I'll give that to you here in just a minute.
Just out of an abundance of caution, we were monitoring the bill also on LegInfo, and we didn't see the amendments yet. So board staff has prepared the packages, and we're disseminating to the members now. And so what you have before you are the amendments that the coalition proposes that I think will be on LegInfo any day now, as well as an FAQ and a fact sheet that was provided by the coalition.
And obviously, I know this is not a Q&A type of thing, but if there's anything we can answer, we can help you with, we're glad to do that. And we look forward to, perhaps in June, having a more substantive discussion with you at your meeting in June.
I'll defer to council. I think we're properly agendized, so we can ask, the board is free to have a conversation.
We can, but in terms of public comment, we probably should not get into too much of a colloquy back and forth.
I just want to say thank you both for coming today. I think it sounds like we're on the right track, according to me. We're going the right way. I just want to ask board staff, right now, are we getting notification from, whether it be Vet Med Board, other boards, in a timely manner for possible violations for a dual licensee?
It is far and infrequent in between. Whether it's in a timely manner or not, I think is kind of the veterinary medical board has to have enough time to investigate a case before they make a decision as to defer it to the PT board, or at least for our investigation. And sometimes that might take a little bit more time. But again, they're enforcing their practice act. So before they're actually deferring it to us, there may be some evidentiary value that, dissipates over time as a result of the delay. But like I said, the cases that we receive from the VMB are few and far between.
So I'm wondering if such an amendment would be necessary. That's what my question is.
As the board might be aware, we are one of those boards in the Department of Consumer Affairs that has a lot of overlap with other boards in the Department of Consumer Affairs, more so I think than any other board, right? So we have a lot of duly licensed folks that are licensed as both physical therapists and chiropractors, or as physical therapists and occupational therapists, or as physical therapists and physician assistants for that matter. And so anytime a board within the Department of Consumer Affairs sanctions one of their licensees who also happens to be a licensee of ours, we have the authority to look at that and determine whether or not there's a nexus to practice, whether it's substantially related, and then act accordingly. So necessity, I think, to Dr. Atlas's point, I think the clarity point makes it a more automated process for that matter, but we have that authority now.
Mm-hmm. Thank you.
Thank you.
I'm sorry, Dr. Atlas, I have a question. I believe there was a question from a member of the board wondering about the advanced certification, and I'm wondering if you have any insight as to what that might potentially look like.
Yes, there are now 3 certification programs in the United States that certify physical therapists and veterinarians to practice animal rehab competently. The other states that have already legislated this area of practice, what they did is they, instead of naming a certain institution to certify these folks, rather they outlined the criteria and the coursework that is necessary to accomplish competency. So what they did was they put out the amount of hours needed and the specific coursework that's needed, and what's in the bill that we are proposing is to have the 2 boards work together to figure out what that competency looks like for the state of California. Yeah, and all the certification courses are overseen by the veterinary accreditation. So RACE, the Registry for Accredited Continuing Education for Veterinarians, is their standard of care and their standard of accreditation, so we can be ensured that those courses are what they say they are, and that they are accredited through RACE.
Thank you. How many states allow physical therapists to practice on animals?
I believe there are 7 now. We have some really good, in particular, there's 3 states that have some really nice outlines, in my opinion. Nevada and Colorado and Nebraska have some really nice regs that are clearly stated and are working well. When I contacted all the board authorities of those states, they had 0 complaints of harm or negligence against a PT practicing on animals. And there's been, that's not even 0 disciplinary actions. This is 0 complaints at all. And they have been in existence, they've been in existence for close to 100 years cumulatively to demonstrate the safety of this kind of practice on animals. So I think we can be pretty assured by our past states that have gone before us on this matter that the model that we are proposing works well.
Are you aware, do you know if there are any states that are silent on the issue so would passively allow physical therapists that don't have express provisions against it?
Oregon
well?
is like that.
Oregon. Okay. And then you said that currently you work with animals. Choosing my words. You work with animals, primarily dogs.
Correct.
How are you able to do that? How do you do that?
So I have a practice whereby I have a managing veterinarian who holds my premise permit. And so the animals first, I require a referral from a veterinarian because I think that is what should happen in the first place. So we want to make sure that all the referring veterinarians are knowing exactly what's happening with their animal patients. So I request a referral from the veterinarian, and then my own veterinarian, on-site veterinarian, establishes a VCPR, a veterinary patient-client relationship, and so then I'm able to work under his supervision.
Thank you very much.
Dr. Drummer, you asked about a Practice Act being silent, and I'm just trying to wrap my head around the materials that we just received, but the Second Amendment that would say the chapter doesn't prohibit a licensed PT from performing animal rehab. If this amendment weren't included, our Practice Act would be silent on that.
I think it's more the intent is deference to our Practice Act, and essentially, and I'll let Dr. Atlas and Mr. Ayers speak to this. Currently, a physical therapist who happens to hold a license with the Physical Therapy Board and has the education to practice in animal rehab under the supervision of a veterinarian, that can happen already. I think what they're essentially trying to say is there's nothing in our Practice Act that would stop them from being able to do that. I think that part currently is silent. This is more of an affirmative statement saying that this Practice Act does not interfere with their ability in that Practice Act.
Thank you.
Is that correct?
Yes.
Okay.
The only comment I want to make about that is that our Practice Act is specific for humans, so which is the rub here, right?
Right.
If it said patients or something more general, then we are looking at more of a silence. But as it states now, since it's specifically for humans, that's what prohibits us from being anything more than an unlicensed vet assistant.
Thank you.
Quick question. So is a referral from a vet to a vet mandated, or?
No. No. It's a mandate that I put on my business because I think that's the right thing to do, and I want to keep everybody communicating well. But that's what the language that we want is to allow for that legally, and to allow that veterinarian who made the referral be the supervising veterinarian, rather than having an on-site veterinarian having to do another exam and then essentially refer to me from there. Veterinarians can only refer to other veterinarians. They are not allowed to refer to anyone else besides their own, which is why I put air quotes around my refer, because they're not really referring to me. They're referring to my practice and then to my on-site vet, who then allows me to practice. Hi.
I was wondering if you can give me an example of maybe like a case that you worked on where there was a canine that needed treatment, how you communicated to your supervising vet, how you know when the animal was fully rehabilitated, things like that.
Yeah. So when I get a patient, say it's a cranial cruciate ligament would be our equivalent of an ACL. So a CCL tear from an orthopedic specialist would refer their, a lot of times it's post-op. So post-op tibial plateau leveling osteotomy is the remedy for that surgically. So the veterinarian would refer the patient for TPLO rehab, and then the veterinarian, my on-site veterinarian, would establish the VCPR, and then I would go ahead and do all the rehab for that. Once I have made my evaluation, then I send my evaluation and treatment plan to the referring veterinarian. My on-site vet knows what's going on, but the referring veterinarian is where I send my notes. So then when my evaluation, and then and the treatment plan for them to say, you know, everything's okay. So if they notice something in my treatment plan, then they would call me and say, hey, you know, pull back on that, or, you know, things are okay. That hasn't happened, but it can. And so then once, you know, oftentimes there's a 2-week recheck and then a 6-week recheck. And so I know when those rechecks are happening, so then I do another reeval and then send my notes prior to the recheck appointment so that we're in communication with the surgeon who did the case. And then they say whether to continue or not, or, you know, go ahead and go gradual back to normal activity, or whatever the surgeon wants, then we follow those orders. Now, is that the law? No, but I'm making that the provision for my personal practice because there is nothing in law, but I think that that's the right thing to do, and so that's how I set it up.
I have a question. So as it stands right now, it sounds like this bill could provide opportunities for individual animal rehabilitation physical therapists to be independent space-wise and not under an on-site, but the ability to practice as long as they have, and it is in this language, referral, right? Or a supervising, I guess, veterinarian, correct?
Right, exactly.
And right now that's not possible? They're not actually technically separate? Is that right?
Which part?
They're not, so you're currently on site with your on-site provider.
Yes.
Are there people practicing that are not on site?
Illegally, they are.
So,
Underground, they are. But that's why we're trying to get this lawful, because that way there's going to be more access for people to bring their pet to those people that are currently practicing the way they are. But that is one of the big things here. So, and you identified it perfectly. So we don't like to use the word independent because that's what kind of sparks the veterinarians thinking that we're trying to usurp them in some way, which we're not. So I don't like to use the word independent. But we are looking for a appropriate degree of autonomy to be able to practice. And yes, that means that PTs would be able to carry a premise permit that is given by the Veterinary Medical Board. It's not a premise permit to open a vet hospital, but it's a premise permit that's very narrow for just rehab services. So it's a premise permit that's very narrow that only a physical therapist with the appropriate qualifications can have. They pay that premise permit, and then they also, and that would allow the vet board to inspect those premises to add another layer of consumer protection. So now we're dealing with the veterinarian who has the ability to make the referral. But if it's a case that they get to choose the level of supervision that they want to for any particular patient, they stay in control of everything, really. But this just gives us an allowance to be able to treat. So, but the veterinarian is the one in control. They decide whether the supervision is going to be direct supervision or indirect supervision. Indirect supervision means that an off-site vet can refer to a off-site physical therapist. Direct supervision is in the same building supervision. And so that is the rub right now, because the it's really hard to form a relationship like I have been able to form for my practice. It's not the easy thing to do. So it would be much easier for a vet to just refer to a physical therapist that has a little bit more autonomy, but stay within the guidelines of what we're trying to propose here. Does that help?
Yeah, thank you.
Just to add to that a little bit, there's a structural difference in the way the two professions are regulated, and Dr. Atlas touched on it with the premise permit. The VMB is very much interested in the setting that veterinary medicine is practiced in, inspections, those kind of things, and registrations, and that's, I think, one of the difficulties. And again, you touched on having an on-site veterinarian to establish that permit, where that idea is somewhat kind of alien to us as physical therapists and physical therapist assistants. It's really more about the license and the autonomy of the license. So in this situation, I guess one of the questions that I would ask mechanically is, and really it's of no concern to me because it's on the other side of the practice, but just out of curiosity, what's the proposal, what does it look like mechanically on the VMB side as far as, is it a certification? Is it a registration? Is it another license type that VMB would be issuing for APR?
We're calling it an authorization of.
Okay.
So it's not necessarily a certification. We're calling it that the VMB can authorize the qualified PT to be able to practice.
And so that authorization of, in a case like yours, would allow you to have a premise permit as long as the authorization holder had both the physical therapy education as well as the specialty certification for canine therapy. That would allow you to obtain that premise permit,
Exactly.
still providing VMB that jurisdiction.
Exactly. You would not be able to get one of these rehab premise permits unless the physical therapist is already qualified with the appropriate education.
Yeah, vetted by VMB. Understood.
So my question would be, if someone holds that premise permit, is that premise permit something that the Vet Med Board can take a disciplinary position on?
Yeah, so that premise permit allows the Veterinary Medical Board jurisdiction to the premise, the inspection of the premise, the approval of the premise, not just faculty and staff, but actual physical sanitation requirements, those kind of things. So, that's the part that for me is kind of like, we have a whole different side of healthcare that handles that part of it. But it's fascinating to me with the idea of, without disrupting the VMB jurisdiction, they're still going to want that ability to inspect a premise for that approval. And so this would just be another or a second condition of where it's not a veterinarian that's on site that creates that premise permit. It would be that authorization certification.
I think where I'm unclear is, here at the board, we take disciplinary action on licenses. So what would that disciplinary action be in this equivalent?
So in this case, I think they're beholden to two different jurisdictions. One, based on the veterinarian that's on site, and that could be something that they discipline, but the VMB still carves out a jurisdiction to inspect the facility and make sure that it is appropriate for clinical care for animals, that its sanitation is to standards, but they can withdraw that as well, right? So coming in and doing an inspection, they can do a cite and fine or a discipline against the actual premise permit.
Bear with me, because I'm just trying to wrap my head around all of this. So then I'm looking at the proposed amendments and the reporting. So if there wasn't action taken on that particular thing that the person holds doing that job, how would that ever get reported to us without this amendment?
So when discipline occurs against a premise permit, and VMB would probably be a much better expert to speak to this than I would, but because that premise permit is attached to a veterinary license, that veterinary license is part of that discipline. And I would imagine that would also apply to the authorization that's going to be applied to a PT in their proposed amendment. So if the premise was not deemed appropriate, the action actually is taken against the authorization of the APR physical therapist.
So it sounds to me like this amendment actually,
Because the two are always married, if there's action taken against the premise, it's also taken against the in this case, it would be the authorization holder, who also happens to be one of our licensees. That second provision that they've included in the language would then make it unprofessional conduct for the PT board. Correct?
Correct.
Thank you.
So we're kind of, we're kind of in a double jeopardy here, actually, because we would be in the Veterinary Practice Act, so they can discipline us, and then you can discipline us too. So it's pretty high stakes, actually.
and we do currently see that with dual license holders
Correct.
across the board,
Yeah.
right? Yeah.
Chiro PT, Acu PT, OT PT, VMB PT, Opto PT. There's so much overlap for PT and other healthcare providers compared to other healthcare providers.
Okay, thank you.
Any further?
Thank you.
Any further comment from the board? And now we're back to public comment.
Just a little additional public comment. Stacy Defoe, Executive Director of California Physical Therapy Association. We just want to lend our support. We're in support of this bill, working closely with Dr. Atlas and her group. And this is an ongoing issue. As you know, we've seen it before. We think the bill, as the language that you will see, makes sense. It provides more administration and more oversight than currently is. And it's, it allows the vet to make the determination on the level of supervision, which makes sense, and then allows for more access for PTs to practice in their own sites. So we are hopeful that this will come to a resolution this year, and we'll do what we can to support this going forward, and that's all I want to say. So we look forward to talking with you more about it in June when you've had a chance to review the language.
Any more public comment? Okay, moving on.
Okay, AB 820, State Boards and Commissions Seniors, was amended on March 20th and is currently in the Assembly Aging and Long-Term Care Committee. This bill requires that the composition of various groups and bodies include a state agency official that advocates on behalf of older adults as defined in the bill. Older adults as defined in the bill is any person over the age of 60 years or older. It's pretty early in the session on this one. I think we're going to be looking at some additional legislative language coming forward.
So my question is, are they wanting someone who is an older adult on boards and committees, or are they wanting someone who advocates for older adults?
As the language stands now, it's both. They want somebody who's going to advocate for that and also have a larger demographic of older adults on boards.
So
and
both
commissions.
and, not either or? Interesting. Thank you.
So this is incumbent upon the appointing authorities.
Correct.
AB 931, prior authorization, physical therapy, was introduced on February 14th and is currently in the Assembly Health Committee. This bill would prohibit a health care service plan contract or health insurance policy issued, amended, or renewed on or after January 1st, 2025, that provides coverage for physical therapy from imposing prior authorization for the initial 12 treatment visits for a new episode of care for physical therapy.
Any public comment?
Stacy Defoe, Executive Director for California Physical Therapy Association. I just wanted to let you know, if you didn't already know, this is a CPTA-sponsored bill. It is another iteration of a bill from last session, but even more simplified than last session because this really does focus on the number of visits that would be allowed before prior authorization was needed. We think this is important because this issue creates a lot of barriers to care, delays for patients, interruptions of care, and burdensome paperwork that adds to the time for PTs to do that could potentially take away from time to practice. So we are hopeful that the legislature will look at this closely and help us move this forward. And we would love the support of the board because we do see this as an access to care and a consumer issue. Again, regarding the delay to care. So we would hope that the board could see fit to take a position on this as well.
And as Stacy and I have discussed in the past, this is kind of a catch-up bill for AB 1000 and just that third-party payers would be paying for direct access. And right now the difficulty is because they're not, it limits direct access to kind of a cash pay basis.
Third-party payers are paying for direct
Some, but
access.
this would
Some
necessitate-
are, not all. It doesn't. This still wouldn't require them to pay for direct access. Most are seeing the benefit of that, and the studies that show that early access to care prevents further, care down the road and further costs down the road. This really is allowing the patient to get all the care that's needed and that's included in their insurance. And that is decided upon by the physical therapist and many times referred by the physician. The ability to get that care right away and continue with that care without any delays or interruptions that come from the prior authorization review process.
Stacy, do we know, are there specific insurance companies that are being a little bit more notorious for demanding prior auth before a patient can get there, or is it?
I think it's kind of an across-the-board thing. It really is. It really has to do, it's more the third-party payer issue. They tend to require that. So if an insurance company is working with a third-party payer, that tends to kind of be the way it goes. And so I would be hesitant to name one in particular. I think it's kind of an across-the-board thing.
In my experience, there are many, and this issue just triggers me as a physical therapist. I know I'm here as a board member, but so many times have I had to wait to see a patient who needed to be seen because I was waiting for someone to authorize it. And it is so frustrating. We are there to help the patient. We're there to support the patient. We're there to provide care, and we can't do it. We just can't do it, and it's very frustrating. So I personally would support this bill.
I have a question, Stacy. Is there a reason or specific evidence supporting the 12 visits? In practice, 12 visits is really very minimal. I'm not saying we need more. I'm asking, is there a particular reason why it's 12?
There are studies that show that's the average number of visits that are required to get the patient what they need. Some practices obviously require more, depends on what the issue is, what the diagnosis is, but in most cases, it's resolved within 12 visits. So it's the same, and there are studies that show that. It's the same number that we used for our direct access bill, 12 visits, 45 days. And that also was based on studies that show that most cases are resolved within that time.
Yeah, I'd be in support of this too, in that I feel that the acuity, that it decreases the acuity, it decreases disability, and gives time for then other entities to evaluate what is further needed,
right.
As the healthcare team. So I think that's a positive thing for consumers in California.
We are anticipating that this will be heard on April 11th. That's our current date for the hearing.
Do you think it would be safe to say that aside from the 12 being the average bout of PT care, that within that range of 12, if it were to go longer, it's more likely that an authorization would occur, by the 5th and 6th, appointment, that would
Correct.
consider and create greater access for the
Correct.
consumer?
Because you're usually talking about higher level cases at that point, if it's going beyond that, and then that's kind of embedded in the process already.
But ultimately streamlining the process for the consumer
Yes.
themselves.
If I could just comment further on my personal experience, you want to be able, as the physical therapist, to do what's right for the client. If that's 6 visits, it's 6 visits. If it's 12, it's 12. But when I get 3, and I can't see that person the second week, and that person just had a surgery or just had a stroke, we have a problem.
And when you say 3, just because of that prior authorization
Just
being
because the
limited to
insurance said,
3?
I'm going to give you 3.
Then that's
Yeah.
a typical.
Very
prior
much so.
authorization. Very typical.
Yeah. But I won't see a patient 10 times if they don't need to be seen 10 times.
Yeah, that's true. Yes, the PT obviously determines the level. The patients have them available in their insurance that they've purchased, and nothing in this says that they have to go 12 visits.
Yeah.
It's definitely up to the physical therapist to determine the level. And there's nothing in this that says that if an insurance company determines that there's a physical therapist who's a bad apple and overutilizing, they can remove them from their system. There's nothing that prevents that from happening. Those
As
are
they do now.
outliers, correctly,
Yeah,
as they do now. But there's nothing in here that changes that.
So I would move to support this bill and direct staff to compose a letter to present to the authors.
Is that a motion?
It is.
I'd second that motion.
Any further discussion? Any public comment? Roll call vote, please.
Tanya McMillian,
Aye.
Dale Armstrong,
Aye.
Karen Brandon,
Aye.
Daniel Drummer,
Aye.
Katerina Ellaby,
Aye.
Jonathan Irvin. Jonathan Irvin is absent. Alicia Ben-Amen.
Aye.
6-0, motion carried.
We appreciate the support. Thank you
Thank
very
you.
much.
And again, staff will prepare that letter and present it to the board president for signature and approval.
All right, AB 1070, Department of Consumer Affairs. This bill was introduced on February 15th and is in the Assembly pending referral. This is a spot bill, and it's relative to the director's duty to notify the legislature of any chief or executive officer position vacancy. SB 259, reports submitted to legislative committees, was introduced on January 30th and is currently in the Senate Appropriations Committee. This bill would require a state agency to post on its internet website any report as defined in the bill that the state agency submits to a committee of the legislature. For the purposes of this bill, report includes a study, an audit, or any report identified in the legislative analyst supplemental report of the Budget Act. SB 764, DCA regulatory boards, removal of board members. This originally was a spot bill regarding the removal of board members if a member disclosed questions in advance of or during an examination. However, it was amended on the 22nd of this month to be a bill regarding minor users for social media platforms, so it's no longer relative to the PT practice. Another bill that was recently amended, SB 770, State Boards and Commissions, that was also a spot bill, and it was amended on the 20th to address unified healthcare financing, so it's no longer identified as an impact to BTBC.
Which bill?
770,
770,
State Boards
okay.
and Commissions. It's on page 75.
Yeah, so, I mean, it's a very simple sentence there, and I saw it, it talks about the composition of state boards and commissions, but
It
just-
was, yeah, it was
Okay.
just a placeholder.
It's been actually gotten amended, and it's a whole different topic now, but it is similar to bills that we've talked about in previous sessions. Or was, now it's completely different.
Okay, moving on to the department-wide legislation. AB 229, violent felonies. This bill was introduced on the 11th of January, and it's currently in the Assembly Public Safety Committee. And on the 15th, it did fail passage in that committee. This bill would expand the crimes that are within the definition of a violent felony, including the purposes of the three strikes law, to include additional forms of sexual crimes as defined in this bill. It's human trafficking and felony domestic violence. AB 996, DCA, continuing education, conflict of interest policy, and this bill was introduced on the 15th of February and is currently in the Assembly B&P Committee. This bill would require entities within the DCA who require licensees to satisfy continuing education requirements to develop and maintain a conflict of interest policy that discourages the use of any continuing education course if the provider of that course has an economic interest in a commercial product or an enterprise promoted in that course. PTBC does already have a conflict of interest policy, which is defined in our regulations under the standards for approval agencies, which is specifically 1399.95 subsection F.
So should this bill go through, will this create a situation similar to retired status where we already have something and we're going to have to look at it all over again?
No. The retired status provision that was granted 2 legislative sessions ago added the ability for any department, any bureau or board under the Department of Consumer Affairs in the general provisions to create a retired status. The conflict that we had at the time was there was additional functionality in that general provision. While we already had a retirement status, we liked the new general provision language. So that kind of derailed us a little bit and set us back because we were switching our authority and regulation from our own practice act to the more general provision because, again, it added additional functionality. It's not to say that something like that might not happen here. We believe that the continuing competency standards that we've had for quite some time that address conflict of interest will address the concerns that are in this legislation. But there may be some redrafting of the language for consistency across the department and that kind of thing. So it might necessitate further regulatory change, but I don't think it's as significant as it was for retirement.
Thank you.
Okay, AB 1028, reporting of crimes, mandated reporters, was introduced on the 15th of February and is currently in the Assembly Public Safety Committee. Current law requires a health practitioner as defined to make a report to law enforcement when they suspect a patient has suffered physical injury that is either self-inflicted, caused by a firearm, or caused by assaultive or abusive conduct, including elder abuse, sexual assault, or torture. This bill would, on and after January 1st, 2025, remove the requirement that a health practitioner make a report to law enforcement when they suspect a patient has suffered physical injury caused by assaultive or abusive conduct.
Why?
Yeah, why?
I think it's the intent of the author to make sure that the mandatory reporting requirement doesn't serve as a disincentive to the consumer to seek out that health care. Right now, if there's an injury that they believe is as a result of an assaultive situation and they go into a hospital setting to have it treated, the inference that that's going to be then reported as a mandatory report might be a disincentive. They may not go to actually seek out that health care. And so I think the author is really trying to address that disincentive.
Couldn't that happen in the other cases as well?
Yeah, but it's very distinct in that as licensed practitioners, you have an obligation to report it based on suspicion. And because of that, they're removing that and kind of putting a little bit more discretion back on the licensee and hoping that that results in some folks who might have that situation will seek out that health care.
I totally oppose this.
I don't necessarily agree with it myself. I'm just expressing what I believe the intent was expressed in the bill.
Where is this at right now?
This one is currently in the Public Safety Committee.
Oh, my gosh.
Let me look too.
I'm almost speechless right now. Like, so this only applies to a health practitioner? So like for myself as a childcare provider, I'm a mandated reporter too.
Right, this only touches on licensees under Division 2 for healthcare.
I'm 100% against this bill. I'd love to find out more of the reasoning behind it and what the expected outcome, the honest outcome that they're looking for.
If you'd like, Brooke and I can open conversations with the author and their staff to kind of give
Yes.
a little bit more insight into the relevance as it relates to PT, and we
Yes.
can bring that back in the next meeting.
Yeah, everyone's speechless. I feel like this is the reason why it was put in place was actually consumer protection. And while I understand that once you identify that you are mandated to report, that may dissuade. I think that the cases that we have lost because people never asked are way greater, you know, in terms of the potential damage and injury to people that persists. And healthcare workers are in a very unique position to be able to be protective of the consumer in this case. So I would really have to see what the deterrent was to communicating or coming and getting care that would outweigh that at this point.
I agree wholeheartedly. I believe that there is a significant consumer protection impact here by the bill. I guess that my hesitation is that it's still so early in the legislative process. There's not even a bill analysis provided for this bill as of yet, because we're so early into the session. But again, it's definitely something that will open a line of communication to the author's office and continue to participate in that conversation.
I think there's more reason for us to address it while it's early, because I would not like to see this thing channeling its way until we find out more. But right now, at face value,
I think I hear your concerns very clearly, and we can express those concerns in those conversations. But if you'd like to go so far as to take a letter of opposition, I understand.
I would like to make a motion to take a letter of opposition.
I have some comment on that.
Excuse me, but Michael Connotes, legal counsel. We have a motion on the floor, so we have to make sure that's been seconded yet. Is there a second for the motion?
Hearing none.
Okay, so the motion dies, and please continue your comments. Forgive me.
I think Jason's attempt to explain the intent of this is not that a healthcare practitioner shall not report it. I think it gives them more discretion and gives the patient a little bit more privacy if they don't want law enforcement involved and for whatever reason they were injured, whether it was a crime they committed or whatever the situation is. I think before we make assumptions about, you know, the intent of the individual or the healthcare practitioner who's trying to provide the care and their requirement to report it to law enforcement, I think we should sort of see maybe the perspective of the patient and give them a little bit more agency and whether or not they want to involve law enforcement in their case. And, you know, their situation, they might choose to avoid health care or access to the health care in fear of or whatever the ramifications may be if law enforcement is involved. So I don't necessarily oppose it. I'd like to learn more about it before we take a hard position on this particular bill.
If I may, thank you, Katerina. Personally, as a survivor of domestic violence and assault, we know that historically women and men now will suffer at the hands of an abuser at least 14 times before they even report anything. And so that's one of the reasons why I am so adamantly opposing this bill, because if you're counting on a person who is being abused to have the wherewithal to make that decision historically, it's not going to happen. And we cannot expect a health practitioner to ignore whatever injuries they are seeing because that patient, and I may be wrong in this, but because that patient does not want them to report it to law enforcement. Sometimes these decisions are life-saving decisions. So that's why I'm so adamant about this, opposing this.
I think as a mandated reporter, I'm sure there'd be some guidance if this were to go through, but the lines would be very blurred for me. I've reported many times to APS. And I mean, if there's suspicion, we report. It's not our job to find out. If there's suspicion, then we report. So this would really blur the lines for me, and I'd be interested in hearing from other licensees here or in the public about that.
The bill as it's currently written, and my preliminary reading of it, doesn't prohibit anybody from reporting. A therapist, Dr. Rubina Amen, you are still enabled to report to APS. This bill does not restrict you from doing that. This bill would only remove the obligation for you to report it. And that, without having the assembly member here to be able to ask them the questions, to find out if there are other organizations behind the author's development of this bill, finding out what it's about, I would hesitate to want to take a position at this point and would want to watch it until the June meeting when more information would be available.
One thing I would add to it, and one, it's a very sensitive conversation, but if you look at it from a reverse sequence, to Daniel's point, is whether or not the failure to report would be a sanctionable offense against your license is the difference here. You could still do it. And for lack of a better word, there is a certain level of prosecutorial discretion as to whether or not that failure is something that a board would take action against anyway, given the circumstances, the variables involved in that case. They're removing this as it being a sanctionable offense against the license for the failure to report. And again, I do see a significant impact to the consumer protection mandate, and it's something that we'll have in conversation. And we may have a little bit more insight from those conversations to bring back to you at the June meeting.
Is there anything that says that the title would be changed from mandated reporter to just reporter?
Not as of yet, no. There are other sections that are covered under mandated reporter.
In my work setting, in an acute hospital, a trauma center, there are very often cases where people who are in after situations of abuse. There are multiple levels of healthcare professionals who, if they all suspect, then potentially, according to current law, every single one of them is required to submit, to report their suspicion. And as the story of the situation for each particular patient evolves with their hospital admission, it changes a little bit. And so sometimes somebody hasn't had that suspicion, but very often that suspicion is there. And so I rely on that another colleague who has documented this previously has reported.
The reporting, when you're part of a healthcare team, allows the practitioners to designate a single practitioner to the reporting. The caveat, the carve-out of that, though, is if you have any hesitation in the trust of that designation, then the default is in guidance that you should also report, just out of an abundance of caution and protection for your own license, for that matter. But again, I think that speaks to that kind of prosecutorial discretion where we look at it on a case-by-case basis and we decide if there was legitimate negligence on the part of a practitioner in that reporting that adversely affected that consumer.
Jason, thank you for sharing the intent or the presumed intent of the authors. I think I'd like to ask also some of our board members who treat pediatrics. I know I treat pediatric urology patients all the time, and if the intent is to avoid suspicion, I can tell you right now, my 8-year-old patient is not thinking about whether or not, the abuse that they're potentially sustaining at the hands of a step-parent that I'm treating for constipation issues and muscle involvement is, they're not going to tell me or share, or they're going to avoid coming to their appointment that someone else brought them to. So I'm trying to understand this in the context of all the patients that physical therapists take care of, and whether or not that is going to be really a barrier to them getting help.
There's certainly some demographical degrees that need to be considered.
So Jason, you can arrange an opportunity for us to hear more from the author.
And even
on
open
the
a line of
basis.
communication. In the past, we have arranged meetings between the board president and the author staffers or the author themselves to have those conversations as well.
We're not the only ones who are having this conversation. What about the other
Certainly
boards?
not. All the divisions will be having those conversations. And again, because it's early in the session, they may be having very similar conversations to what we're having now.
Let's do that then. Let's make that arrangement.
All right.
Any public comment?
Thank you for the discussion. I think it's been a good discussion. I think when our Government Affairs Committee reviewed the bills, I'm not sure, this may have changed in between then, so it looks like maybe it was a spot bill originally and now it's something more than that. So I'll just let you know that we'll take it back and we'll take a closer look at it, and we'll be watching it, and thinking about a position and that sort of thing. So appreciate the discussion, and we'll continue that with the board. So if you hear of anything and you want to let us know, if you get more information, we would be happy to hear it. Thanks.
Thank you. Okay.
AB 1751, opioid prescriptions, information, non-pharmacological treatments for pain, was introduced on February 17th and is currently in the Assembly Health and Business and Profession Committees. Current law requires a prescriber, before directly dispensing or issuing for a minor the first prescription for a controlled substance containing an opioid in a single course of treatment, to discuss specified information with the minor, the minor's parent or guardian, or another adult authorized to consent to the minor's medical treatment. This bill would extend that requirement for the prescriber by applying it to any patient, not only a minor, and would also require the prescriber to discuss the availability of non-pharmacological treatments for pain. For purposes of this bill, non-pharmacological treatments for pain are defined to include, but are not limited to, acupuncture, chiropractic care, physical therapy, occupational therapy, and licensed mental health provider services. SB 14, serious felonies, human trafficking, was amended in the Senate on February 23rd and is currently in the Senate Public Safety Committee. Current law defines the terms serious felony and violent felony for various purposes, including, among others, enhancing the punishment for felonies pursuant to existing sentencing provisions commonly known as the Three Strikes Law. This bill would include human trafficking within the definition of serious felony for all purposes, including the purposes of the Three Strikes Law. The last bill on the legislative summary is SB 816, Interior Designers. This bill was introduced on the 17th of February and is currently in the Senate BMP Committee. This bill is the Business and Professions Committee Omnibus Bill. In addition, this bill would establish the California Council for Interior Design Certification to govern the certification and regulation of interior designers.
The only thing I would add to that is you may be asking why we're including the interior, but, and Brooke touched on it, this will be the omnibus bill for all of the BMP. So any kind of minor modifications that Department of Consumer Affairs boards and bureaus are asking to be included in the bill could hang on the interior design conversation. So it's just we're not interested in the interior design side of it. We're interested in the omnibus bill side of it.
I like the way that you presented this whole ledge section with those specific to our board and then those that are others. And I'm a physical therapist, and this is all language that isn't always familiar to me, so it's very helpful to go through this. And your comment is very helpful. I'm just wondering if that is something in a case like this where we might want to spell it out for the public, you know, so that they're aware. I mean, if we're looking at it going, huh?
One of the difficulties this early in the legislative session with spot bills is sometimes it's difficult to know what the effect is going to be even a committee or two in, right? So while we put them here, especially with this omnibus, and this is a very clear example, we could be clearer on the language for the public. There's a good possibility that the omnibus bill overrides and another bill maybe gotten amended and interior design is moved to, I mean, there's so many variables that can happen in these conversations this early in the process.
Any comments from the board on any of the information on the legislative summary? There were other bills.
I had a quick comment, a question for our staff. Do we have information back to the opioid one? I'm sorry that I missed it, but I wanted to understand maybe who else might be supporting that.
I think of interest, those bills that are listed as, Brooke kind of mentioned acupuncture and occupational therapy, those alternatives, if you will, to opioid medication, I would assume it's definitely on their radar as well.
And any opposition yet for that?
Not that we're aware of.
Okay.
At the June meeting, some of this will fill in, right? So you will see bill analysis, you will see letters of support, letters of opposition, and in those letters of support, opposition, and even in the bill analysis itself, a list of who the stakeholders are on either side. So that will probably help also.
After, yeah, definitely. Any public comment? I'm hearing none. So let's take a 10-minute break, and then we will return and continue the rest of the meeting.
Thank you.
Our meeting, I think we are on agenda item 19, rulemaking report.
All right, we currently have 3 regulatory packages that we've been working on over the past few months, past few years, and I want to thank our regulatory attorney at DCA, Heather Hoganson. She has been instrumental in the forward progression of these rulemaking packages. Ms. Hoganson has accepted a promotional opportunity at another agency, and we will be assigned a new regulatory counsel probably in the upcoming months. We wish Ms. Hoganson all the best and express our appreciation for all the hard work that she has and her dedication on these packages, and we've greatly enjoyed working with her over the last few years. The first rulemaking package that I'm going to talk about is the coursework tool, and we're happy to report that the coursework tool regulation was approved by OAL on December 14th, and this regulation became effective January 1st, 2023, as we did ask for an early effective date from OAL. The next rulemaking package is the performance evaluation tool, the PET. The final rulemaking package was submitted to OAL on November 7th, 2022, and during OAL's review, they had concerns regarding clarity in the proposed language, specifically in subsection G, and we withdrew the rulemaking package on December 21st, and the proposed language was modified per OAL's recommendation. The modified text was noticed for a 15-day public comment period from February 9th to February 25th, and no comments were received. The modified proposed language I will go into further detail and will be presented for board consideration under agenda item 19B.
I have a question. The regulatory unit, I'm just wondering, it was at OIL for final review. So whatever was recommended by them, is that something that might have been caught sooner in the process? By us, by the reg unit, by the first notice with OAL? It seemed like it happened late in the game.
So you're correct. It went to OAL for final review, and OAL counsel, in their analysis of the bill language, saw a clarity issue for the perspective of the public. Thank you. Is it something that could have been addressed either by us as staff or counsel, reg counsel from DCA beforehand? Yes. But I don't think that it's a fault on either party's part. I think that's, to a certain extent, it's part of the process. This is a very technical in nature kind of point of clarity that was made. And for us, there is a certain amount of bias in the understanding of the language. We knew exactly what it meant and could not really see it from the same perspective as the OAL attorney who's representing that kind of public clarity. Could it have been caught clear? Sure, it could have, but I will give and echo Brooke's sentiment to Heather Hoganson. While we've waited a very lengthy amount of time for all of these packages, and I don't mean to belabor the topic, we have made a significant amount of progress with that assignment and a kind of a diversion of resources to get these done. As you'll see in this one, we're already back and ready to present that language to you, to turn around and hand it to OAL on a pre-acknowledged correction. So the effective date will still be right where we kind of anticipated it to be. And I would also echo that I'm sorry to see Ms. Hoganson move on to another department. And we will hold our expectation of performance to be the same regardless of whatever that reassignment is. But again, I think while I don't necessarily disagree that it could have been handled earlier in the process in assessment, it's also not unusual. I mean, that's what OAL's assessment is for, is to really affirm those. And this hasn't provided much of a hindrance. It's provided more work, but not a hindrance in the timeline.
You know, just to add, I've been doing regulatory packages for the better part of 20 years, and really where the rubber meets the road on OAL's duties is that final review. And so these types of small language changes at the end of the process are very, very typical and common.
Thank you.
You're welcome.
Can't wait to see the language.
The retired license regulation was approved by OAL on December 8th, 2022, and also became effective January 1st, 2023, as we did ask for an early effective date from OAL. If we had not done that with OAL's processing times, they would have been effective April 1st. For the continuing competency regulations, as Sarah talked about in the strategic plan yesterday, we are still in the process of researching and developing proposed language for consideration by the board at a future meeting date. So we will bring those forth when we have that prepared. And that concludes the regulatory report. Did the board have any questions or additional questions?
Any public comment?
Brooke, is there any, can you share any ideas with regard to continuing competency about topics that are being considered that are thrown in the air right now?
I can do that. There's a couple things that staff will probably provide as a recommendation for edits to the CCR regulations. One of those is clarity about the requirement for BLS, or basic life support for a healthcare provider. Right now we have an hour attachment to it, and we're finding that the certification itself is probably more reliable. The hour attachment can be confusing for practitioners. Sometimes it's a 4-hour, sometimes it's a 2-hour. It depends on initial or recertification. Sometimes it matters in the size of the class if they're attending that it's done in a certain amount of time, and so that certification of hours is really ambiguous. So that's one of the things that we want to do for clarity. Also, kind of making the alternate pathways a little bit more prominent so that licensees have a clearer understanding that there are a number of different ways that you can get continuing competency credit. I will say, I think the alternate pathways list is very complete, and it's just a matter of outreach also. But there may be some regulatory change that results from that.
One of the things that I would suggest considering is adding language that would include serving on the board as a potential for satisfying requirements, a portion of the requirements. Currently, that is not in the, serving on a committee, I believe, is there of the board, but serving as a board member itself is not there.
We'll take that down in consideration.
Seeing as how that will no longer, I'm not
benefit
crossing it.
from
I'm not
it?
crossing any boundaries with that at this time.
It's an appropriate outgoing statement, I think is what you're saying.
Yes. Any public comment? Okay. Moving on. Agenda item number 20.
19B.
19B.
Where am I at? Oh, sorry about that. 19B, thank you.
Okay, so this is addressing the possible adoption and consideration of public comments on CCR 1398.26.5, clinical service requirements for foreign educated applicants completing a supervised clinical practice in the United States. And as mentioned in the rulemaking report, during OAL's final review, they had concerns regarding clarity in the proposed language. And they specifically said that 1398.26.5G is unclear. The text requires the user to create an account to access the PET. The issue is that user is ambiguous and could be interpreted to mean either the supervisor and/or the applicant. While the proposed text doesn't define user, the initial statement of reasons more specifically describes the effect of G, which is that the user would be the supervisor of the applicant. As is, because the text doesn't align with the effect described in the record and the term user could be reasonably interpreted to have more than one meaning, this proposed language is unclear. OAL recommends modifying the text to clarify the provisions of G and then making the modified text available for a 15-day notice and comment period. So as I previously reported, we did withdraw the proposed rulemaking file and modified the language per OAL's recommendation. No comments were received during the 15-day public comment period. The proposed modified text is on page 88. And highlighted in yellow, it shows the edits most recently made to the text. The modified text first updates FSBPT's website to include the direct link for the pet, and additionally, it clarifies that the email to be used is not the user as defined in the originally proposed language, but that of the supervising physical therapist, which addresses OAL's clarity issue.
And those points of clarity are found on 89, under sub G.
I have a concern about including specific references to certain items, because those items can change. Those, for example, the URL, the web address for fsbpt.org/SCPPET, that may change, and if that does, this currently lives in regulation, then the regulation has to then be modified later. And so rather than identifying the specific URL in this case, identifying the web page that is related to, or the FSBPT web page related to the pet. Some language to that effect to me seems more appropriate.
So for this particular purpose, to a certain extent, I agree. And those conversations and considerations were had, not just with Rate Council and OAL, but also with FSBPT to assure that something like that, the link wouldn't change without advance notice. But because it's incorporated by reference, it's very specific. If something like that, well, when I say it's very specific, I mean the requirement is that it's very specific. If something like that would change and it wasn't substantive in nature, like the location of a URL, we could make that change with a Section 100 regulatory change, which doesn't encompass this whole regulatory process. It allows us to do edits to things like addresses and reference points and revisions to documents, those kind of things, as long as they don't also have a substantive change with them. But we did have and did provide a little bit of resistance back with a very similar idea to that. And unfortunately, that's one of the requirements for clarity at OL now, is that if it's incorporated by reference, that it's very specific.
If my recall is correct, we seem to have gone down this path with OAL in the past when specific references were, as I just mentioned, or as what I was wanting to address, OAL required removal of those specifics.
It has been.
In past episodes of
It has been
regulation.
my experience in the tenure as the administrator of this board that there is this pendulum, if you will, that kind of swings back and forth based on the administration. And it is a trend issue, I think. I think maybe Mr. Knotes can help me address this, but as part of the approval, as those administrations change, so does the art in which we write that language.
Thank you.
Any public comment?
So there was a motion on page 87 of the meeting materials, should the board choose to adopt the amended language and proceed with the rulemaking process. The final steps of the rulemaking process would just be resubmitting the final rulemaking package with OAL for their review and asking for this regulation to become effective upon filing with the Secretary of State.
So the language in physical therapist and physical therapist assistant education has now changed from center coordinator of clinical education. And if we should make a change now, would that cause problems with this package?
That change was actually part of earlier initial review. The only change, so you've already approved that change.
But I don't see it here. It says center coordinator of clinical education, and it's now site coordinator of clinical education.
Sorry, Alicia, where are you looking? Where are you reading?
Sub C?
Sub A.
A.
And sub C.
And sub C. And really, so the distinction is just site and center?
That's correct.
Okay. My recommendation would be that we can address that, and we'll confer with DCA Reg Council. I think that's also something, it's a title, if you will, and that might be something that's considered a Section 100 change that we can address in the future. I wouldn't recommend changing it in this particular package. We already have a well thought out agreement with OAL on how this process is going to move forward. If the board accepts the recommendation of staff in the motion, this reg will go into effect very quickly. We can always address the title in another package.
So just to add, if we wanted to make any changes at this point, we would have to put the reg back out for another 15 days, and then we would have to address the new language at the meeting in June. It is a non-substantive change, and I don't see any legal problems with us proceeding and then making a Section 100 change at some point, but that, of course, is within the discretion of the board to hold it.
And the Section 100 change will just start the process now.
And those usually only take about 45 days. As it stands now, if this reg isn't effective upon filing with the Secretary of State, it'll go into effect July 1st, just according to OAL's processing timelines.
Do we receive applications from foreign-trained physical therapist assistants?
We do.
And so just for completeness of the background then, I understand it's a background statement, it's going to go away, but the APTA did develop a CPI for PT assistants, which is separate from the one for physical therapists.
And I'll probably ask Sarah Conley to help me out in this conversation. For foreign-trained physical therapy assistants, the clinical requirements are not the same. And so the performance evaluation tool wouldn't apply to them, which is why it's not mentioned here. So the CPI, the use of the CPI for PTAs, for foreign-trained PTAs, is not a requirement that we currently hold.
So, okay, so foreign-trained physical therapist assistants do not have the clinical requirement.
Correct.
To be, for their application process?
Correct.
Okay. On the bottom paragraph on page 85, the sentence reads, "The purpose of supervised clinical practice for physical therapists that did not graduate from a CAPTE accredited program is to promote public protection," et cetera. It's because there are potentially physical therapists graduating from non-CAPTE approved programs now in the United States. That I understand that this reg is to address foreign trained, but there are students graduating from non-CAPTE accredited programs potentially. This board has the ability to approve education programs that might not necessarily have CAPTE accreditation.
Sure.
And so,
While we defer to CAPTE accreditation, the board reserves the right to either approve additional schools outside of CAPTE's accreditation or refuse currently CAPTE accredited programs for cause.
right.
And I think to your point, at least what I'm discerning is that for non-CAPTE accredited within the U.S., if the board should ever make that decision, that will be encompassed in an entirely different process than what's intended here, and we'll have an opportunity to be able to discern what those requirements look like.
Thank you.
Any more comments? Dr. Joyner? You turned your mic on?
Move to adopt section 1398.26.5, including the incorporated forms as amended by the notice modifications and authorization of the executive, and authorize the executive officer to take steps necessary to resubmit the rulemaking package to OAL to complete the rulemaking process, including making any technical and non-substantive changes to the proposed regulations as necessary.
Okay, any further board discussion?
Yes. So I have not used the PET, and I see the proposed language in G that the supervising physical therapist must enter their email first and last name, create a password, and this is how they're going to create an account. I'm just wondering, why is this even in here?
It has to do with the incorporation by reference requirement at OAL. Because we are deferring to an electronic system, we have to incorporate the entire tool by reference. So dissimilar from what's already existing for the 1996 CPEI on paper, because there are additional steps required to adhere to the use of the PET. It has to be incorporated in its entirety by reference into the regulation.
So why aren't we including the applicant's instructions to create an account?
Once the account is created by the supervising physical therapist, the door, or the entry to the portal is created for that applicant. So the applicant no longer has a requirement other than to participate in the tool itself, but not the initial setup of.
Okay.
Any further board comment? Any public comment? Hearing none, can we take a roll call vote?
Tanya McMillian,
Aye.
Dale Armstrong. Aye. Karen Brandon,
Aye.
Daniel Drummer,
Aye.
Katarina Ellaby. Jonathan Irvin. Jonathan Irvin is absent. Alicia Benamen.
Aye.
6-0, motion carried.
Thank you, Brooke. Now moving on to agenda item number 20, Administrative Services Update with Alicia Hernandez.
Good morning, everyone.
Good morning.
First, I'd like to introduce myself. My name is Alicia Hernandez, and I am pleased to join the PTBC as the lead analyst in the Administrative Services Unit. With that role, I commit to monitoring the budget and reviewing it on a daily basis. So with that said, I'd like to present the Administrative Services Update as it relates to the budget report. So basically at this time, we are at a status quo. We are definitely on track. Going into the Q2, PTCB reports expenditures for Q2 for the state fiscal year 22-23 at $1.7 million, which is just a slight increase from last year's Q2. However, on the plus side, PTBC has reported a 5.52% in revenue collection, which is about $2.2 million. Historically, it's been shared with me that the increases usually are typically about 2 to 5% year over year. So with that said, we're in a good position at this time. Other than that, I don't appear to be any action needed as a part of the budgets report. And again, I commit to ensuring that I'm reviewing and monitoring the budgets and revenue expenditures.
Any comment from the board?
Welcome, Alicia.
Thank you.
And thank you for your commitment to look at this closely on a regular basis. It's so important.
Most definitely, yes.
Yeah.
I've come from the Employment Development Department, so we had a huge budget, and I worked with a lot of our team as well. So it's something that's always in the radar. So you got it.
Thank you.
I will tell you, as the administrator, that commitment sets my mind at ease also. typically being solely responsible for those numbers and the anxiety that comes with it, I know that if I walk into the office in the morning and I just glance at Alicia and she just kind of glances back and we're good, that's enough communication for me that we're on track.
That's right.
In addition, I'd say, for the end of Q2, we're right at 55%, right? And so that's a good range to be in. But I think, to Alicia's point, and more importantly, we're living within our means, right? So we have additional revenue that even kind of compensates for that, that'll be addressed in the fund condition over time. So.
Any public comment? Hearing none. Thank you, Alicia.
Thank you. Again, thank you, everyone. I just have to, as a side comment, the PTBC was very welcoming and accommodating during these first couple of weeks. Jason has an amazing team, and I'm proud to be a part of it. Thank you.
Thank you.
That is unsolicited kudos.
I don't know, it might have been prearranged.
Moving on to agenda item 21, licensing services update. Valerie Kearney.
Good morning.
Good morning.
Having implemented the changes detailed on the strategic plan, the applications unit is heading into the PT and PTA graduation season with no backup of applications. With regards to the application statistics, of the 46 non-CAPTIA accredited applications received in Q2, 20 of those were by endorsement. We also received 2 applications for electroneuromyography certification, bringing the total of ENMG certified current PT licensees to 24, and there are 29 current KNMG certified PT licensees. The 1,402 initial license applications received represent an increase of 9% over Q1 and Q2 in 2022. 98% of those applications received were submitted online. 93% were U.S. educated, and 65% were, 93% were U.S. educated, with 65% exam applicants and 35% were by endorsement. Foreign educated, that is non-CAPTIA accredited, and military applications were 7% and 3% respectively. I'd like to call your attention to the fact that 2 of these statistics reports are now system generated. Those are the application services and the license maintenance statistic reports. The license maintenance statistic report includes average processing times, and we hope to include processing times on the application services statistics report by the next board meeting in June. With regards to the processing times shown on the license maintenance statistics report, all these times are rounded up to the next whole day. For example, if a task is completed in 2.6 days, the system will round that figure up to 3 days. And if the processing time on the report shows 0, that means the task was processed immediately, as is the case with address changes, which are completed mostly online. And even those address changes processed by staff are completed so quickly that only 0 values are shown. Mailed-in renewals processed by staff, you'll see, are at 2 days processing time. With processing time so minimal, each change is very impactful. And these processing times indicate just how efficient the unit is. License maintenance staff has implemented the retired license status regulation January 1st, 2023. Also in January 2023, licensee requests for verifications sent to other states was reassigned from the CPS unit to license maintenance with no discernible impact. The continuing competency audit statistics report does contain a typo, my apologies. The number of PTs who failed the audit should be 6, not 13, for a total of 19 for Q1 and Q2, not the 26 shown, for a total of 229 PTs audited during the 2 quarters. Otherwise, the numbers are correct. With a pass rate of 94% for PTs and 97% for PTAs, licensees overall are in compliance. Approval agency audits by the continuing competency team are ongoing, and today's agenda there are 5 agencies for which withdrawal of their agency approval status is requested. Should we look at those?
Any questions regarding the report materials themselves?
Yes, what are the 2 automatically generated reports? One was license maintenance and one was something else.
The application statistics.
Oh, great.
Those are both system generated through Qbert.
Oh, great.
And we're working to get the processing times added to the applications received statistics as well.
I think my other question has to do with initial license application data summary. So we get a good chunk from exam, we get a good chunk from endorsement, and then we've got 7% foreign educated. Thank you for providing this, by the way. This is good information. I appreciate it. And 3% from military. Do we still have an analyst appointed to the military applications and 1 analyst to the foreign educated?
Yes.
And I know that the workload for the different types of applications is much different. So I would imagine the foreign educated was very convoluted. It's a convoluted process, and
It's
It
a
is.
higher level of analysis. There's a lot more criteria that, in this case, Teresa Gutierrez has to look at and kind of maintain with foreign trained applicants. The 9-month clinical service is probably one of the most significant, but also just verifying who the clinical instructor is, where the clinical site is, the approval of that, and then the assessment at 2 points during that clinical instruction. Also, before that's even done, if they happen to be an endorsement candidate, verifying their work employment and trying to give them a month-to-month kind of waiver for that clinical site requires a little bit more analysis. And it's really case by case at that point.
thank you.
I have a question for you. Do you know where most of our foreign educated applicants come from? Or is there a specific?
The foreign educated? I don't right offhand. I'd have to look into that for you.
Statistically, I don't have numbers,
Yeah.
but anecdotally, I can tell you the Philippines and India are the
Philippines,
primary
right.
2.
And I'm wondering if there's any outreach we can do for schools or programs that feed a lot of applicants to our state. I know that was one of our thermometers, was looking more into the foreign educated application process. Maybe we can do a bit more proactive outreach towards those areas that tend to have.
So for non-CAPTI accredited or CAPTI accredited outside?
Foreign educated.
Foreign educated? We can, it would be very similar in the outreach that we're trying to provide for outside of California schools. So the idea would be application pathways, graphical interfaces, those kind of things, video tutorials. But for foreign educated, just trying to distribute that information to the schools. One of the things that makes it a higher level analytical position for Teresa Gutierrez is having to, at times, reach out to those schools for verification of education as part of the FCCPT and the IERF certification, that the point of contacts are not easy to come by. Right, because we're so out of touch with them over time that once we do establish one, it can change And actually, all of the information for that particular school can change, and we would never be aware of it. It's not as regulated as it is here. But it's definitely something that we could put as part of the foreign pathway so that that information is readily available.
I know, Kat, it brings up the concept that we have a lot of schools that take post-professional programs, and then those people end up wanting to practice in California. And so I wonder if we can at least ask the local schools for their,
Yeah, we certainly keep that line of communication open at all times. All of the CAPTE accredited programs have liaisons designated that staff have a direct line of communication with, and we distribute information in both directions for that.
And I think one of the reasons why I keep asking about the website is I'm so interested, because I know that that's where they're going to go. They're going to go to our website. So I know that we can make that digestible and helpful. And not that it isn't so much now, but I think when you go to certain websites and you're someone like myself who isn't real tech savvy, and I can just, I just have to go there. I just have. Not that everyone needs that, but someone like me needs that. So that's what I'm hoping for our website.
I mean, there's a whole new web etiquette, if you will, right, and the analysis of how a website performs, right? Essentially, the fewer clicks, the better, right? And we kind of touched on it yesterday in the strategic plan closeout, is that that's one of the reasons why we felt that particular objective was not completed, because we haven't been able to give that same attention to the foreign trained. So it's coming, and it's an ongoing project. But it speaks to that higher level of analysis that makes it a little bit more difficult to create a pathway. The pathway goes in a lot different directions for foreign trained.
I like the fact that California does receive so many applications from foreign educated PTs. You know, they're talented. I work beside them. They have a lot to offer. And so I'm glad that we're a friendly state to that. So it's great that we're going to give that more attention.
Board members, Valerie did pose the question if you wanted to have further discussion on 21C.
We are definitely going to get to 21C. But if there are no further questions for 103.
Okay, so can we move forward with?
You want to move forward with reviewing those?
Yes.
Okay, very good, thank you. All right, so the first one is Life Care Centers of America. You can see that there's been multiple attempts to reach out to this company with no success.
I move to withdraw the approval agency recognition from Life Care Centers of America.
The next one is,
Hold on one second.
I'm sorry.
It was purposeful.
Any public comment? Okay, then we need to get a roll call vote.
Tanya McMillian.
Aye.
Dale Armstrong.
Aye.
Karen Brandon.
Aye.
Daniel Drummer.
Aye.
Katerina Ellaby.
Aye.
Jonathan Irvin. Jonathan Irvin is absent. Alicia Ben-Amen.
Aye.
6-0, motion carried.
All right. And the next one is Los Robles Hospital and Medical Center.
Dr. Drummer, you want to make a motion?
No, I'll wait for the next one.
I move to withdraw the approval agency recognition from Los Robles Hospital Medical Center as a reasonable opportunity was given for agency to respond.
Second.
Any further discussion?
Tanya McMillian. Dale Armstrong.
Aye.
Karen Brandon.
Aye.
Daniel Drummer.
Aye.
Katerina Ellaby.
Aye.
Jonathan Irvin. Jonathan Irvin is absent. Alicia Rubin, amen.
Aye.
6-0, motion carried.
And the next one is Milestone Continuing Education.
Move to remove approval agency status recognition from Milestone Continuing Education of Fort Wayne, Indiana, as a reasonable opportunity was given for agency to respond.
I'll second.
Any further discussion? Public comment? Roll call vote, please.
Tanya McMillian.
Aye.
Dale Armstrong.
Aye.
Karen Brandon.
Aye.
Daniel Drummer.
Aye.
Katerina Ellaby.
Aye.
Jonathan Irvin. Jonathan Irvin is absent. Alicia Rubin, amen.
Aye.
6-0, motion carried.
And number 4 is Pacific Alliance Medical Center.
I move to withdraw the approval agency recognition from Pacific Alliance Medical Center as a reasonable opportunity was given for the agency to respond.
I second.
Any further discussion? Any public comment? Roll call.
Tanya McMillian.
Aye.
Dale Armstrong.
Aye.
Karen Brandon.
Aye.
Daniel Drummer.
Aye.
Katerina Ellaby.
Aye.
Jonathan Irvin. Jonathan Irvin is absent. Alicia Rubin, amen.
Aye.
6-0, motion carried.
And the last one is Pathways, Home Health and Hospice.
I move to withdraw approval agency recognition from Pathways Home Health and Hospice as reasonable opportunity was given for agency to respond.
Second.
Any board comment? Public comment? Hearing none, roll call vote, please.
Tanya McMillian.
Aye.
Dale Armstrong.
Aye.
Karen Brandon.
Aye.
Daniel Drummer.
Aye, aye, aye.
Katerina Ellaby. Aye. Jonathan Irvin. Jonathan Irvin is absent. Alicia Rubin, amen.
Aye.
6-0, motion carried.
Thank you.
Thank you very much.
You know, I would just like to highlight that you will probably see more of these at future meetings. One of the trends that you might see with the 5 that are here today is that they were all some of our first recognized approval agencies, some of them going back 10 years, 12 years. And so shoring those up and touching on the audit of the recognized approval agencies, we've found that some are just no longer in business. You know, they've fallen off the map, if you will. So staff has very diligently pursued them. As you can see, for some of them, a lot of communication effort was done to try and get in touch with them before we actually bring them to you. And some of this is 6 months in the works. So.
On the website, some of the ones that we are removing the approval for have a strikeout.
Correct.
Will that be different on the new website? Will they just not be there, or will we move those to a second section?
Well, the decision that we had made was kind of for historical purposes,
Yes.
for those licensees that are returning to the website to verify those, and also for some of these agencies, while we may not have been able to reach out to them now, and maybe they haven't done anything recently as far as providing content to our licensees, they may want to in the future. And so they might find out for the first time by visiting our website that this has actually happened. And so we put that in strike line. We intend to carry it over. With that also comes that kind of legend that we put for the services that each approval agency provides. But I think what we will be doing is taking them out of that alphabetical selection and moving them to a section where all of the previous recognition would be acknowledged at a lower part on the page.
Without a strikeout?
I don't know that we've thought that much.
Yeah,
I think it'll have a description as to why the list is there and what it's for.
Yeah.
But I think strikeout serves as a very symbolic visual. Like it's when you look at it and you see that there's strikeout, there's something, it causes attention.
Okay, I just interpret it as a draft.
Good point.
Yeah.
I have a question for clarification since I'm new to this component here. For a licensee who had a history of getting their CEU, CME continuing before today or before it's actually put into place, would they not be able to utilize the credits that they got from these agencies?
So we would look at what language was put into place at the time that the class was attended, right?
Okay.
And so if there were classes provided by these agencies, and keep in mind, we only audit back to the last qualified renewal period.
Yeah.
Typically. We may, once in a while, reach back further as part of a spot audit, but if they provided content and the class was recognized by the board at the time through the approval agency, we would give credit to the licensee for the attendance.
Okay, so if they have a completion certificate on a date that was before,
Absolutely.
yeah, okay, just verifying.
And not to say that there aren't remedies, and this is the example with these 5. If they are still in business and we just failed to be able to reach them, and one of our licensees seeks them out, attends a course, as long as the course content follows the continuing competency regulations, meaning that it's physical therapy based and patient-client relation based, there are other opportunities for the licensee to be made whole, right? So there are other agencies that can take a look at that particular course and provide a content credit for it. These recognized approval agencies can go back through the process and do a retroactive approval. So not all is lost, I guess is my point. We're never trying to make it more difficult for the licensee to maintain their continuing competency.
Are approval agencies required to maintain any kind of status with us, any updates for example, every 2 years, every 5 years, submitting a letter, we're continuing to
the regulatory
provide
authority
service?
the onus is actually on us. So, well, it goes both ways. If we make the request, they are to respond.
Right.
And so there's nothing set in stone that says they have to do something with every 2 years, but as they are solicited by board staff to provide, as an example, an updated list of the content that they approve,
Right.
they have to provide that within a reasonable amount of time.
And
This is kind of the result of that
right.
request.
Is there a set time period as to how often staff is doing that?
No, and in fact, in the past, and especially during the pandemic, we weren't, right?
Right.
It just didn't allow, our primary condition is the audit of the licensee. The secondary would be those approval agencies and making sure that they adhere to the continuing competency regulations that the board set forth.
Right.
That audit is now picking up more steam, right? And so we're going through that whole list of recognized approval agencies, making sure they're in adherence to their initial application. It's a difficult library of content to kind of maintain.
Absolutely.
But that's one of the beauties of that CCR section is that while the licensee's main, requirement is to maintain their records for 5, the recognized approval agencies is 7.
Right.
And so we should always be able to go back and verify that content was approved by one of our agencies.
And I'm anticipating that there are a number of approval agencies that sought approval, but then just never provided any education. It was
Absolutely.
something that they thought that they were going to take on, and then ultimately didn't. So their agency status was granted initially, but then they haven't done anything now for how many years have we had this?
The regulation went into effect in 2010.
Okay, so 13 years.
Yeah. And I don't know of an example that quite fits that. So most that applied for recognition were either providing their own content, or they wanted to be the approval agency as a shop
Right.
for other content providers to get recognition in the state of California. So I think some of those that did file with recognition for us might have had the intent, but maybe only a few courses at the time, and it might be still an ongoing course that they provide. And then some have even changed kind of their business models from just doing their own to now doing their own and that recognition for others, or that certification for others.
Okay.
Yeah. Any further board discussion? Any public comment?
Stacy Defoe, California Physical Therapy Association. Yeah, that's where I work. I noticed that the continuing competency regulations are on the rulemaking calendar, and then and it looks like the regulations are still in development at this point with the board. Nothing's been, but I'm wondering if there will be an opportunity for public to be involved, and if so, will it be in the normal rulemaking calendar, or will there be an opportunity earlier than that, like there was with the initial drafting of the regulations?
So there's no plans for the board to put together a task force like they did with the inception of the regulations, but there is always that opportunity, and even, I would say, probably an expectation of staff for stakeholders to participate in the promulgation of those regulations. Typically, it does happen after board staff has made a recommendation of proposed language to the board, but in an instance like the professional association, there's always an opportunity for us to put it on our quarterly meetings and make sure that that input is given to, and we would welcome it in advance. So anything that we do provide as recommended language, we'd like to have as much of it shored up as possible.
That's appreciated. Thank you.
Along that topic, is the expectation that the review of the rule, the regulation, include the items related to approval agencies and that process?
So
and not just relevant to the licensee and the particulars of what qualifies?
Absolutely. I think that the authority that we have in the CCR now, as far as recognized approval agencies, is very flexible, at least from the perspective of the administration of the board, because those authorities are there. And to your point, like a necessary frequency, setting an expectation is one thing, but also being able to actively monitor based on conditions helps also. Like, so when a licensee brings to us a concern about, an issue that they have had arise from a content provider or a recognized approval agency, we will reach out to those recognized approval agencies directly and start to address that situation. But because the conversation is open and we're looking at an edit to the continuing competency regulations as a whole, that's always certainly part of the conversation. The one thing that I would say is there are two conceptual ideas, and I probably could address this when you asked me, what the proposals were for continuing ed. There are edits to the regulatory language in mind right now that staff have talked about, like BLS and the alternate pathways. But we also have an authority to fund the continuing competency program in our statutes, and we can collect fees from either the licensees, the content providers, or the recognized approval agencies. And we've absorbed that cost for the better part of 13 years at this point. And so moving forward, as we have increased skills and services, we're going to have to look at a fee assessment on one of those three groups to determine what's appropriate. And that will be handled in a separate regulation.
Forgive me if I missed this. So we do audits on our licensees. Do we do audits on our approval agencies or content providers? We do?
This is an end result of that
Yeah.
preliminary stages we're going through and shoring up the recognized approval agencies. As part of the recognized approval agency audit comes kind of a pseudo audit of the content providers. If the recognized approval agency has given an accreditation towards a particular course, that's part of that audit. So the content, is it appropriate? Is it established at the right credential hour? Is the provider who's actually presenting that material is qualified to do so. All of those things are part of that recognized approval agency's audit.
Any further discussion? Again, any public comment? Okay, moving along to agenda item 22, Consumer Protection Services Update. Carol Phelps.
Good morning.
Hi, Carol.
I'm Carol Phelps. I'll be presenting agenda item 22, the update on the Consumer Protection Services, or CPS program. At our last meeting in December, I reported on some big staffing changes. I have a couple more changes to report. Analyst Vincent Azar transferred to his new position in the admin unit in December, and I began serving as a CPS manager in February. Although with these changes, we are currently short-staffed, we are working to fill the vacant positions to alleviate the increased workload on our remaining analysts as soon as possible. The new facility site visit inspection checklist that was mentioned in our December briefing paper is now being used by investigators and expert consultants during site visits. This checklist was created to aid them in conducting thorough investigations, giving them a list of things to look for as they're doing their site visit. We will be seeking feedback from them and making improvements to that checklist as we go. As of the beginning of December, CPS staff now has access to LexisNexis, a public records database that allows the analysts to look up information on individuals we are investigating, such as address history, phone numbers, criminal record data, license and business information, etc. This tool has already proven useful in many cases, from obtaining a more current address for a licensee to finding location and contact information on unlicensed individuals that are alleged to be practicing PT in California. Prior to having this access to LexisNexis, we would have had to refer cases to the Division of Investigation, or DFI, to obtain this information. So this is a much quicker tool for us to have. We continue to meet monthly with the supervising special investigator over DFI's enforcement support unit. The purpose of these meetings is to have an open line of communication between the board and DFI to discuss urgent or high-profile cases, as well as other enforcement-related matters that may impact both the board and DFI. We are currently working on reviewing and updating DFI's procedures specific to investigating physical therapy board cases. We also continue to meet monthly with our DAG liaison as needed for guidance on cases and to discuss and review improvements to specific procedures and to the overall discipline process.
Carol, just a second. And if you weren't aware, many of you have met the DAG liaison before, but he was with us yesterday during the petition, John Gatchett, who is local in Sacramento. And so when we call, he comes. And it makes it a very streamlined process for us.
Yes, thank you. The CPS unit has experienced many changes this year and has implemented several new tools, procedure updates, and improvements to make the board's investigation process as efficient and effective as possible. Staff has met each new challenge and change with flexibility, cooperation, and support, both to each other and to board management. They are truly exceptional at what they do. We have a wonderful group of people working in the enforcement unit, really great. So regarding the CPS statistics report that's in your board materials, this is attachment A. The report covers the fiscal year through quarter 2, which is October to December of 22. Performance measure 1 reports the number of consumer complaints and arrest or conviction reports the board received. While we have received slightly fewer conviction and arrest reports, which is great, compared to this time last year, we have received slightly more consumer complaints in that same time. Performance measure 2 is the average number of days to initiate a complaint once received and to acknowledge receipt of the complaint to the complainant. The target for this performance measure is 9 days. Our year-to-date average is 4 days, which means we are meeting this target. Performance measure 3 is the average number of days to complete investigations and enforcement actions for complaints that are not transmitted to the AG's office for discipline. Case aging averages went down in comparison to the same time period last fiscal year. These numbers, as I'm sure you've all heard before, are known to fluctuate greatly because they reflect an average of all cases. They encompass the entire investigative process that involves timelines, workloads, response times of not only our CPS staff, but of all involved parties. A handful of complicated cases or cases where pandemic-related issues have caused a lengthy investigation can increase these averages significantly. The target for Performance Measure 3 is 180 days. Our year-to-date average is 169 days, which means we are meeting this target. Performance Measure 4 is the average number of days to complete investigations and enforcement actions for complaints that are transmitted to the Attorney General's office for formal discipline. Case aging averages for this performance measure have increased compared to this time last year. This could be partly due to cases being completed in this quarter that had experienced pandemic-related delays. As you can see in the last section on page 2 of the report, labeled total orders, aging, final decisions, 7 out of the 11 cases that were closed last quarter had aged over 3 years, which means all of those cases were opened pre-pandemic. Although we are seeing things return to normal and pandemic-related issues are causing fewer delays, the statistics reported here may still reflect higher processing times as cases that had been delayed by earlier COVID shutdowns come to completion. Attachment B to this report is a discipline summary of all disciplinary actions taken by the board in Q2. 1 licensee was issued a public letter of reprimand, and 9 licensees were placed on probation. This concludes my report. I'm happy to answer any questions.
Any board comment? Discussion?
I'd like to know how staff finds the utilization of Breeze for board member voting, because, you know, as a board member, I have my own perspective. It's fine. It's just one more place to go to do something when we used to get in the email, which is already secure, but I'm thinking that it's probably creating some efficiencies for staff.
I do think it does create some efficiencies for staff, but I would, guidance from DCA and their OIS, especially their chief information officer, was to move voting to Breeze and to touch on what you just touched on with it being secure. So email is, in their argument, less secure than your visiting the DCA portal Breeze and logging in, making that vote, accessing the documents from that. So the guidance department-wide was to move all board voting to Breeze for that purpose. And while we've been doing that now for quite some time, and it has its difficulties, I guess is probably the best way to say it, we've felt our way in the dark and figured out how to do it efficiently. It's not as simple as doing it through the email side of things. It's still in compliance with that advisement from DCA. So we won't be returning back to doing it through the email platform. There may be some improvements that are coming as a result of our use of and our experience with the Breeze portal and voting and how we display documents to you. But the biggest concern for us would be the security of those documents, because you do have arguably very sensitive, identifiable information that's contained in those documents, and we want to make sure that those are as secure as possible.
I, for some reason, now have to enter my password twice to get into my DCA email. I guess I feel like it's very secure. And if you travel out of country.
Twice, or when you say twice, you mean the VPN portion of it, or?
You know, I just admitted I'm not a techie person, but
Okay. I
log in with my username, I put in my password. It takes me to another page, and it makes me enter my password again.
Okay.
Yeah.
There is a new layer that has been probably 4 to maybe 6 months total. Yeah, there's a new layer. It asks a question about, do you want to update things or something isn't updated. I've been able to just skip past it.
Okay.
There's a way to get around it, but it's like it's asking for another level of security.
Multi-factor authentication.
In a way.
Okay.
But
yeah.
because you can just hit the back button and get past it, like it's not really there.
We'll reach out to OIS to figure out how necessary that is. As board members, you are, because you hold a DCA email address, for the security of that information and the protection of your own private information, but you're treated very much the same way we are as civil service employees. So those questions, we are held to that same standard of multi-factor authentication. That's an unnecessary step, I think, for you, but so I'll reach out to OIS and make sure that maybe there's something that we can do to at least remove that unnecessary layer for logging in. I share the same frustration. Every time my laptop times out, I have to type in what really now is a very long password, very complex, long and password requirement that's just changing every 90 days. So, but to their credit, OIS is really adhering to Department of Defense standards and audits from the DoD as far as information security. So some of these things are necessary.
I can tell you, I log in, and then it takes me to a home page where you can choose the LMS or your email or whatever.
Okay.
So I choose my email, and then I sign in again, and then I have to go to my phone and say, yes, it's me.
Yeah. So that part I can help you with, because as an example for board members, when I text you that you have DCA email, we can probably give you an idea of what that DCA email is regarding, and if it happens to be a case, you don't have to go to the first one. We can give you the direct link that takes you to the Breeze portal, and so you can kind of bypass that. That first initial portal that you're talking about offers you all the different kind of things that come with your DCA email address. The online Outlook version, LMS, Moto, those kind of things, which a lot of them don't apply to you because you're board members. But, so we'll give you direct access, straight to Breeze.
But that 3-point check isn't secure enough for
Oh,
us to
yeah.
vote online
Yeah.
or vote by email. I get it, I'll do what I'm asked to do.
There is a possibility, if we were still doing it in kind of what they see as the antiquated Outlook fashion, that those emails can be intercepted, and then that personally identifiable information is at risk.
Carol, thank you for a concise, clear, well-presented report.
Thank you. I appreciate that.
Very much appreciated.
And welcome aboard.
Thank you.
Because you mentioned the text message alerting us, I've noticed that that has been a little inconsistent in the past few months. Haven't received a message, a text message regarding any kind of, different kinds of board business where something is necessary for me to attend to. And there's a timeline attached to it. And I happen to go check my DCA email maybe once a week if I remember to do it, just to see if I missed something, because this has happened a couple of times. And there's a message, a repeat message, email, just a reminder that so if staff could alert you to a need, we need board member response.
Yeah.
To then make sure that board members are getting that notification, because like I said, I don't go into my DCA email unless I know that I have to.
Right.
It's not a regular daily thing like I have to do at work.
Absolutely. Right.
I understand that it is what staff have to do every day at work. So I understand the separation, but it's a challenge.
We should probably make sure that I have your right contact information, because I do text you quite frequently.
Oh, yes, you do.
Okay.
No, and I've received a number of them.
Okay.
There have been a couple of times, though, when there was a response that was required for me, and I just happened to go on to my DCA email and notice that there was an email or two emails that I'd never received a notice from you that there was something to review.
Unfinished business.
Yeah, there's nothing there. So, so something potentially related with the message, case voting, or something that addresses something in the message that addresses what it's about, and then maybe even time frame, because there have been times when I get the text message and I go and it's like, it's a week out or a week and a half out. It's like, okay, I have a little time. I don't have to do this right now.
Sure.
Where there's other times it's like, I was supposed to do this yesterday.
Okay. Yep.
So then I okay, now I have to get on.
And,
So
the consistency probably comes from kind of a changing of hands of authorities and stuff, but we'll address that. The same part is, there have been times where I've sent email reminders specifically for, there's a case pending and we don't have enough votes collected. So that, but we'll do a little bit better of a job and consistency from one case to another.
On the topic of Breeze voting, I don't know if other members have had this experience, but sometimes there's no due date when there's a new case in there. So I don't know if I need to submit a vote today, tomorrow, so there could always just be a due date.
Sure, okay.
We will do that. That's part of our procedure, but we'll double check and make sure that's done every time.
Any public comment? Hearing none, we will move on to agenda item 23, probation monitoring services update with Carol
I will
still
also be
here.
presenting that report to you. At the end of Q2, there were 82 licensees on probation. Of that total, 70 probationers were actively practicing in California. The remaining 12 probationers were tolling, meaning they were not receiving credit toward the completion of probation because they were either not practicing PT or practicing in another state. There were 8 licensees placed on probation in the quarter, and 0 licensees completed probation in the quarter. Of the 70, of the 70 licensees that were actively practicing at the end of the quarter, 8 were enrolled and participating in the board's drug and alcohol recovery monitoring program, which is about 11% of all licensees actively on probation. There was a high of 12 participants in the program during the quarter. 4 licensees enrolled in the program in the quarter, and 2 licensees completed the program. Of the 4 licensees that entered the program, 1 was deemed to be clinically inappropriate after the clinical diagnostic evaluation and was released from the program. No licensees were terminated or withdrew from the program for any reason during this quarter. And again, this is October to December 2022. The probation monitoring unit remains busy as usual with our 1 probation monitor, along with monitoring the 82 licensees on probation. He also has been working on several petitions for early termination. This concludes my report. I'm happy to answer any questions.
Any comments, discussion from the board? Hearing none. Any public comment? Hearing none there. Thank you,
Thank
Carol,
you.
for that report. Now, moving on to agenda item 24, any public comment on items not on the agenda? No public comment. Item 25, agenda items for future meetings. July 21st through 23rd, 2023 will be in Sacramento.
June.
What did I say, July? June 21st, correction. Okay, oh, go ahead.
We used to have some brainstorming ideas, I guess from time to time, and then staff actually did a good job, like looking through and seeing what we might want to do, but I think we've kind of been in a dry period since we got back to live meetings.
We used to have a parking lot of topics, and we've kind of made our way through those. But again, if there are any things that you would like us to address at the next meeting, we also have training components. We still plan on bringing you demonstrations of services from DCA, the Department of Justice, the Office of the Attorney General, DFI, those kind of things that we do on this kind of 2-year recurring cycle. That particular board meeting, we also have that first day of strategic planning, and we'll try to address that in the single day, but there is the possibility that we have to take things out of order if one day runs into the next or something like that. So, but if there's anything that you'd like us to add to that parking lot, we will try to make the arrangements for those.
Thank you, Jason. Okay. Any public comment? Hearing none, then we will not be coming back for closed session. We've covered everything, so We will adjourn this meeting. It is now 11:55 a.m. And we will see you all in June. And lunch is in the back.